Hello guys, welcome to this video. Today we are going to look at a case law. The case that we are going to look at is the case of Liversidge V Anderson that took place in 1942. So let us first of all construct and find out the context of this case. So here is the context of the case. The participants of the case are one, Robert Liversidge, who was the accused person. Then we have John Anderson. John Anderson was the Home Secretary. This case took place in England. Why did it take place? This case concerns civil liberties and separation of powers. Liversidge was suspected to have hostile associations and the Home Secretary Mr. John Anderson. Robert Liversidge was put to prison without reasons being given for this. These are some of the reasons that prompted this case. So let us now get into the nitty-gritties and look at the case in details. So Liversidge v Anderson of 1942 is a landmark United Kingdom administrative law case which concerned the relationship between the courts and the state, and in particular the assistance that the judiciary should give to the executive in times of national emergency. It concerns civil liberties and the separation of powers. Both the majority and the dissenting judgments in the case have been cited as persuasive precedents by various countries. So precedent in judicial term means like something that is of great example, like something that is worthy of emulation. For example, how a case has been handled before may be something that is used today. So that is what we call judicial precedent. So let us look at the facts of the case. Emergency powers in Regulation 18B of General Defense Regulations of 1939 permitted the Home Secretary to intern people if he had a reasonable cause to believe that they had hostile associations. So here the keyword to underscore is hostile associations. Hostile associations in this context means relationships with enemies of the state or relationship with actors that may jeopardize the national security of a state. So the power that the Home Secretary had was to intern people if he had a reasonable cause to believe that they had hostile associations. Sir John Anderson exercised this power in respect to a man called Jack Palsworth, who used the name Robert Liversidge. You note that he did not use his real name. So he committed, the Home Secretary committed this gentleman to prison, but giving no reason at all. So he just put him in prison and that's it. On appeal, the case joined with that of Ben Green and reached the Appellate Committee of the House of Lords, the highest court of appeal. They had to decide whether the court could investigate the objective basis for the reasonable cause. In other words, could they evaluate the Home Secretary's actions on an objective standard, comparing them to that which might be taken by a reasonable man, or where they measure them against the personal standard of the Secretary. So we have to understand here we have a legal problem, information, because it appears that some information is classified and only the Home Secretary has access to that information. So you find that this information asymmetry may have led to the misunderstanding, because here we have a man who has been put in prison without being given any reason, and may be due to national security reasons or highly classified information. So this puts in an element of uncertainty and an element of confusion, especially on the part of the judges and the people who are going to now judge the Home Defense Secretary. So here is what the judgment in the House of Lords took this shape. The majority of the House Lords in the House of Lords held that legislation should be interpreted so as to effect what Parliament intended, even if it meant adding to the words to give that effect. Although Parliament had made the power subject to reasonable belief, they accepted Home Secretary's statement that he had held such a belief. In other words, that he believed that he had a reasonable court. The majority of the Lords appear to have been greatly concerned with the fact that they were dealing with a matter of national security. In their view, it was not appropriate for a court to deal with matters of national security, especially if they were not privy to classified information that only the executive had. So in a dissenting speech, Lord Atkins stated his view. The majority had abdicated their responsibility to investigate and control the executive, and were being more executive minded than the executive. So Atkins was of the view that they were not minding their business, instead they are minding the business of the executive. Lord Atkins protested that theirs was a strained construction put on words with the effect of giving uncontrollable power of imprisonment to the minister. So in fact, Lord Atkins was truly very against these arbitrary powers and having ambiguous criteria for action, especially action that jeopardizes the freedom of others. So in England, amidst the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as also in peace. It has always been one of the pillars of freedom, one of the principles of liberties, for which in recent authority we are now fighting, that the judges are no respecters of person and stand between the subject and any attempted encroachment on his liberty by the executive. So we see that Lord Atkins affirmed something very, very important, that the rights of a person are beyond national security concerns, and that no person can escape safely because they are powerful. They can maybe cause harm to other people because they use this. If we let what the majority of the Lords have the day, then it will mean that more and more people can be politically prosecuted using national security as a scapegoat. So this judgment or the opinion of Lord Atkins is very, very important, and has formed a formidable foundation for most of the case laws or most of the administrative decision making that takes place in countries worldwide today. Thank you for watching this video. Like, share.